Before we start the next session, I would like to say a huge thanks to our sponsors who play an important role in this event even being held. Astigaraga Davis, Martin Kenny & Co., Kinetic Partners, Cayman National, Invest Barbados, Secure Hosting, the Cook Islands Financial Services Development Authority, the Ministry for Financial Services in the Cayman Islands, Cayman Finance, Murant Ozan, Zolfo Cooper, the Employment Law Group, Freeborn and Peters, Chris Global, Bennett Jones, the BVI International Financial Center, Foreshore, Whistleblowers Against Fraud, KK Forensic, Hush Blackwell, the BVI Association of Compliance Officers, the Cayman Islands Compliance Association, ICC FraudNet, the Cayman Financial Review, Low Tax, Global Tax and Business Portal, KYC 360 Degrees, IFC Review, the Proceeds of Crime Lawyers Association, and the Global Incorporation Guide. So now I would like to introduce our next speaker who, if he hadn't retired from the IRS last summer, wouldn't be here this year because of the sequester. And Dan Reeves, before he retired, was the pioneer of many of the investigative techniques and methods that the IRS have been using with what I would describe as wild success to obtain information about U.S. taxpayers who have been doing things illegally. So Dan is going to talk about his experiences leading the IRS investigation into offshore tax structures.
Okay, well, thank you, David. And now for something completely different. It was interesting when I walked up here, I heard them playing the Beatles' Taxman. And I was thinking to myself, I wonder if there's a song called The Ex-Taxman, because that's what I am now. I'm an ex-taxman. First, I want to say it really is a great pleasure for me to be here again at the annual Offshore Alert Conference. Those of you who've been here before know that, or may know that I've attended probably 6, 7, maybe even 8 years in a row at this conference, and always found that it was, if not the best, it's certainly one of the best offshore conferences around, because it doesn't just bring together people of like mind, it brings together people of different views. And we get to share ideas and we get to share experiences. And I can tell you that over the years I've learned a great deal from some of the people in this room right now about offshore, some of who are pro-offshore, and still through the knowledge I gained from them, we were able to start looking at offshore and understanding it. I remember many years ago, before I went to work on offshore, I used to investigate gambling casinos around the United States for what's called anti-money laundering programs under the Bank Secrecy Act. It was my response. I led a team of agents that went around investigating casinos to see if they were filing currency transaction reports, suspicious activity reports, and those kinds of things. And through those efforts, I learned that you had to understand the industry that you were investigating. You know, we were very successful with the casino industry primarily because we took the time to learn it and understand it. And that accomplished many things. First of all, it allowed us to be successful, but secondly, it minimized the unnecessary burdens that we placed on the casino industry at the time. And I think we did the same thing with the offshore industry. Coming to this conference and others, we learned a great deal about offshore. And through it, I think some of the successes that we're going to talk about now actually resulted from that. So again, I thank David for inviting me back again. And hopefully you will find this interesting. I do have to tell you that, as he said, I feel somewhat like the Lone Ranger up here today, because in the past there have always been some federal people out there, either IRS or ATF or DEA or somebody out there, but today there is not one single federal employee in this room because of the sequester. So with that, let me give you a little personal introduction real quick. My name is Daniel Reeves. I did retire from the United States Internal Revenue Service in June of last year after serving 35 years as an IRS agent, the last 10 of which I spent investigating offshore tax evasion. So the perspective that I'm going to bring, the discussion that I'm going to make is related to my experiences as a law enforcement and regulatory compliance officer. That's the perspective. Someone who has investigated offshore tax evasion for more than 13 years and who has conducted some of or led some of the highest profile offshore tax investigations that IRS has conducted. What I'm going to do is tell you a little bit about my own experiences and what we learned throughout this process, and how we ended up achieving some of the great successes that I believe we have achieved. Before I do, however, I do have a couple of caveats that I need to give you, a couple of disclaimers. First of all, I am here appearing as a private citizen now, so any of the comments or opinions I express are my own. You should not assume that they are the opinion of the Internal Revenue Service, the United States Treasury Department, the Department of Justice, or the United States government in general. They are my opinions and my own. Second, I still remain covered by the same rules of confidentiality that covered me when I was working for the IRS. So I will not be telling you any heretofore unknown secret details about any investigations I led or any other matters that might have been under my official control when I was working. What I am going to do is tell you about my experiences investigating offshore and investigating the financial structures and financial arrangements that are set up. I'm going to talk about the program that we created at the IRS called the Offshore Compliance Initiative. And I'm going to tell you about some of the successful projects we developed, some of the successful investigations we conducted, and some of the information we learned along the way. Now, when I look at offshore, or when I look at the journey that I've been on, at least with regard to offshore, I see it as four separate and distinct periods of time. First, there are the pre-Offshore Compliance Initiative days, the pre-OCI days. Those were before we had a real program in place. During that period of time, the IRS struggled generally for how to deal with offshore. Offshore was like Vegas. What happened offshore stayed offshore. We didn't have any sources of information. There was nothing that we could go to identify people. Really what happened is it became a question of serendipitously finding someone who was offshore. An example might be that someone during the course of a normal investigation might be looking at checks and turn the check over and notice that this particular check was deposited into an account at a bank in Antigua. And so they might say, well, it looks like this person must have an offshore account. Let's take a look at this. And that would begin the offshore investigation. But we really didn't have any strategic programs or initiatives that could proactively go out and do that. How do we go out and find these people? Then came what I call the pre-UBS years. Those were the years when we started getting a handle on what was really taking place. We started identifying people. We had some very successful programs, which I will describe, that went out and they were successful in identifying U.S. persons who had secret offshore bank accounts and bringing them back into tax compliance. The most important part about those days is that we learned a great deal about offshore. That was the period of time when we began to understand how the offshore world worked. And we began to understand where there were sources of information that we could go to that would help us find U.S. taxpayers who were committing tax evasion. Then came the UBS years, and those are the years we still find ourselves in today. That was a period when large advances took place by the IRS and the Department of Justice in dealing with the issue of offshore tax evasion. I stand up here, and I should make this point, I stand up here not to campaign against offshore, but rather against offshore tax evasion. That is, the commission of tax evasion is a crime in the United States. It is punishable by imprisonment, and those who do it, whether they do it domestically or offshore, are at jeopardy. And in our case, IRS had been very successful dealing with people who were trying to evade tax in the United States. It was the offshore component that was a problem. And during the UBS years, we made great progress and continue to make, I say we like I still work there, I don't work there anymore. The IRS made great progress and continues to make great progress in addressing the issues caused by that. And then finally, there are the post-UBS years, which are coming, and that basically is where everything is headed, or at least my opinion of where everything is headed. And I will share that with you. Some may agree, some may disagree. Oh well. So with that, let me start by saying that, that offshore certainly isn't what it once was. There was a time when going offshore was absolute. It was absolute secrecy. You could go offshore, you meaning a U.S. citizen, could go offshore, open up a bank account, set up an offshore structure like an IBC or a foreign trust or some other entity, put it on the account as a nominee entity, and pretty much there was no way that anyone was ever going to know about it. The only people that would ever know about the fact that you owned this account were you and your private banker. That was it. We knew that we had to find some way to get around that. So what we started doing is we started to study the financial industry extensively. When I say we, I should point out that a small team was created in 1999 to look at offshore tax evasion. There were 3 people involved, a brilliant international agent from New Jersey. I'm not going to give you his name only because I don't know if he wants his name out there. But he was a member of the team. An attorney by the name of John McDougall, who many of you I know are aware of. John is very extensively involved in offshore. He and I became partners after the other individual had left, and the 2 of us carried the mission forward, so to speak. He's also very extensively involved in the offshore voluntary disclosure program, so I'm sure you've run into him if you do any kind of offshore disclosure work. And then myself. And the 3 of us, we studied the offshore industry extensively. We interviewed many people who were involved in the industry. We attended offshore conferences, including this one. Some where offshore tax evasion was not just openly discussed, but it was actively promoted and as a way of increasing your own personal wealth. We gained a considerable amount of knowledge and understanding about how the industry worked. And based on that understanding, we basically came up with 4 questions to address how we would look at offshore in a proactive way. First of all, and by the way, these 4 questions are generally regarded as the key questions when it comes to understanding offshore structures. First of all, how did the taxpayer get involved in offshore financial arrangements? Was this something, in the old days, in the Jerome Schneider days, for those of you who remember that name, you would get on a plane and there would be a booklet in your that booklet that comes in the pocket of the seat in front of you, and in there were always ads about going offshore and setting up corporations and stop paying taxes and the like. There are airports in the Caribbean where when you fly into the airport there are signs everywhere telling you here's where you want to go open up your offshore bank account. I went on a vacation with my wife to an offshore financial center, purely vacation, that's all it was. And when we got to the room, I opened up the book that comes there, and the first page was saying, if you're a U.S. citizen, come visit us at this bank, and we'll help you set up an offshore structure where you won't have to pay taxes in the U.S. anymore. So how did they get involved in it? On the other hand, was it a lawyer, an attorney here in the United States who maybe suggested it as a way of wealth management, asset protection, or any of the other commonly used terms for tax evasion? Secondly, how are the assets expatriated offshore? Once you've got this structure in place, how do you move the money? How do you actually get funds transferred? And there are a variety of devices that are used. It depends on whether you're in business, whether you're an individual, whether you're someone of high wealth. You know, the thing about offshore is that with the global economy and the ease of the internet, offshore has actually been reduced from something that was once the provenance of the wealthy to where the affluent are now able to take advantage of offshore. So how did they move the money? How did they get the funds off there? Third, how do you control the money when it's offshore? You know, there are some financial centers that are very well regulated, very, you know, if you move your money there, you really don't have too much of a problem. There are some others that I think we all know that if you put your money in that center at a bank, that bank may not be there next week. So how do you control the money and make sure that when you need it, it's there? And then finally, how are offshore assets repatriated when you want them? When you want the money, how do you get it back so that you can spend it? You don't want to just put it in an offshore bank and leave it there forever. How do you bring the money back? And those became the four key questions that we developed out of this project. And what we did is we looked at them as choke points. These were places where information and opportunity came together. Because all offshore transactions involved these 4 points. So we started thinking, if we start looking at these as choke points and start figuring out where we might be able to identify records that have passed through one of these occurrences, that's going to create opportunity for us to identify U.S. citizens who are committing tax evasion. Now, the project we came up with was called the Offshore Credit Card Project. And the Offshore Credit Card Project was an answer to that fourth question, how are assets repatriated? What we learned was that for the most part, if people moved monies offshore, the way they got access to the money was through a credit card. And it really wasn't a credit card, it was a secured credit card, which meant that behind every single credit card, there was also a bank account. And the bank account had to have more money in it than the credit line on the credit card. So if you got a credit card from a particular bank in one of the islands, you wanted a credit line of, let's say, $20,000, you had to have a minimum of possibly $30,000 or $40,000 on deposit with the bank. Didn't mean you didn't have $1 million on deposit. You could have had $10 million on deposit. But the key was that if you had a credit card issued by a bank in one of the offshore financial centers, you also had a bank account. And we weren't interested in the credit cards, we were interested in the bank accounts. This was simply a way to find out who had them. Now, we needed a tool to be able to get these records. And we did a lot of research through our own regulations, and we came up with a tool called the John Doe Summons. The John Doe Summons was a unique type of summons that the IRS had authority to issue when it did not know the identities of people. It was very rarely used in those days because most IRS investigations or examinations involve someone. And I don't know if any of you have ever seen a traditional summons issued by the IRS, but the first line of it says, "in the matter of the tax liability of," and then you put someone's name down. That's the person you're investigating. And that's what gives you the authority to go get their bank records. Well, in our case, we didn't have names. In fact, names were what we were trying to get. So we couldn't say in the matter of the tax liability of this person. So what we did is we came up with in the matter of the tax liability of certain John Does described herein. So basically what we're saying is we're going to describe, we're not going to identify people, we're going to describe them by characteristics. Now, a John Doe summons can be used to get information on people whose identities are not known. The authority to issue is the same as for any summons that the IRS issues. The difference is that a John Doe summons requires the approval of a federal district court judge. And why is that? Essentially, with summons law in the IRS is required to give notice to the person who upon whose records are being summoned. So if we're investigating you, the summons would say in the matter of the tax liability of so-and-so, and we would issue that to the bank for your bank records, and we would send a copy to you. You then have a certain period of time during which you can go into court and try to block the compliance with that summons. Well, in the case of John Doe's, there is no one. We can't give notice because we don't know who these people are. How are we going to notify them that they can come in? And so they don't even know that we're going for this summons. So in order to meet that requirement, there was placed a new burden on the IRS, which basically said, if you're going to issue a John Doe summons, you need to come before a federal district court judge and get approval to issue the summons. Now, that became huge for us because there's something called Section 6103 of the Internal Revenue Code, which says that everything that the IRS does cannot be disclosed. Much as some in the offshore world have absolute laws of secrecy, the IRS is prohibited by law from sharing or disclosing this information. But in order to get it approved, we have to go to a federal district court judge where everything is conducted in the public view. So what this did was it gave us the opportunity to put into the public arena all of the information we had as to why we believed these people should be turning over their records to us. And quite frankly, if you look back through the last 10 years, all of the information that has made everyone or many people so interested in what IRS is doing has come out of those John Doe summons declarations where we lay out chapter and verse, this is what's going on, this is what they are doing. All of the types of devices that are being used and the, in some cases, clearly unlawful and illegal acts that are being committed by the bank in question or by employees of the bank. So it lets us get it out into the public view, and that applies pressure on people to come forward and correct their tax matters voluntarily, which is really what the IRS wants. The IRS staffing does not permit it to go out and audit every taxpayer in the United States. You know, I used to have a saying that when I would speak internally at conferences, I used to say the offshore tax evasion problem is not a problem that we can audit our way out of one tax return at a time. We have to deal with massive, large blocks of people and deal with them in some effective way. And the best way is to make them come in themselves and take care of their own tax matters. And how do we make that happen? We make that happen by basically saying we've identified your bank or your country or your whatever. If you had, not you, meaning the people in the audience, meaning the unknown taxpayers out there, the likelihood is that we're about to get your bank records. And you better think about coming in before we come knock on your door, because everything changes at that moment. To get a summons, a John Doe summons approved by the court, it must relate to a particular person or an ascertainable class of persons. So it must be something that, if it's a single person, that's easy. But if it's a class of persons, which the offshore John Does usually are, we have to describe them with certainty, and it has to be something that is ascertainable. We can't say everybody who has an offshore bank account you know, is a redhead. How is anyone going to identify that through their banking records? You know, it has to be something that you can clearly define and that the bank can comply with, or the summons party rather can comply with, and something that the judge can look at and say, okay, I understand who this class of people are. Secondly, there must be a reasonable basis for believing the person or group of persons has failed to comply with any internal revenue law. And it can be any law. It doesn't have to be tax evasion. It can be anything. This is where most of the work goes into in terms of the John Doe summons investigations. And if any of you have ever seen some of the original John Does that we served, such as the first ones in October of 1999 when we served Visa, MasterCard, and American Express, the declarations that went with those summonses were binders that were like 3-4 inches thick with evidence, because we had to make the argument and convince the judge that there was a reasonable basis for believing these people were committing tax evasion. As time went on, and as you start setting precedent after precedent after precedent, it becomes less important and smaller argument to be made. There was a John Doe summons issued last week, I'm sure some of you heard, in connection with the U.S.-owned accounts at First Caribbean International Bank in the Caribbean. If you read that summons, that's only a few pages, because most of the arguments have already been made, they've been accepted, so we don't have to keep fighting the same battle over and over again. But that's where most of the work goes. It goes into that second requirement of demonstrating that there's a reasonable basis for believing that these people have committed tax evasion. And then third, the information sought and the identities of the person must not be readily available from any other source. And that's pretty easy to make in an offshore case, because the only people that have the records are the offshore banks. And they're not about to give us the records. So we have no alternative but to find some other way to get them. So as I said, the first project we came up with was the offshore credit card project. It received extensive media coverage in the 1999 and the early 2000s. It was the first one that really went out and systematically addressed offshore tax evasion. When we issued those summonses, we were literally on the front page of the New York Times, the Wall Street Journal, the LA Times, the Herald Tribune. You know, it was amazing how quickly that became a major news event. And it was very successful for us as a project. We served summonses on MasterCard International, Visa International, American Express International, and then we moved on to companies that are known as third-party card processors. These are, those first three are what are known as primary card processors. They're the major worldwide international systems that process all credit card transactions. But there are third-party processors. These are smaller companies that do the back office work on behalf of banks that don't want to have a large staff to process transactions. And what we found was there were banks located in financial secrecy centers that used third-party processors here in the United States to process their credit card transactions. Well, those transactions might have been secret in whatever jurisdiction they were located in, but those records sitting in Florida or Denver or Atlanta, those were not secret. Those were subject to U.S. laws because they sat on U.S. soil. So we served John Doe summonses on a company called Credit-O-Matic of Florida, located right here in Miami, on one called Technicard, also here in Miami. We served one on First Data Corporation, which is one of the largest card processors in the world. They're located in Denver, Colorado. And on a company called Total Systems Incorporated, or TSYS, which was located in Georgia. And basically what we did with those John Doe summonses is say that with regard to any credit card issued by a bank in any of these listed jurisdictions, and we listed the countries that we believed had financial secrecy laws that were being exploited by U.S. taxpayers for tax evasion reasons, we wanted to get all of the records related to those accounts. And again, they were very, very successful for us. And then we served John Doe summonses on over 150 merchants located here in the United States. This is where we identified that U.S. persons were using credit cards, but we couldn't tell who they were. But we knew that the merchant would know. So for instance, if you bought something from a mail order site and paid for it with your offshore credit card, the mail order site knew who they delivered it to. If you bought a large item, such as a car, using a credit card, the car dealer knew who they sold the car to. If you bought something that involved warranties, those companies knew who held the warranties. There were a lot of different things like that. You know, one of the summonses we served was on AOL, back in the day when AOL was the primary ISP in the country. And it was really interesting, and I had an AOL account in those days. It was interesting because you had to get your AOL account charged to a credit card. And your account number, your AOL account number, was actually your credit card number. So we served them a John Doe and said, basically, everybody who used a credit card, just tell us who they are. You start thinking about this stuff, and you start realizing that there are all kinds of different ways that you can go out there and start identifying people. It's really just a question of resources and of course, doing something with the data. If there's anything that a court does not like, it's to invoke the power of the court and then not use the data that you obtain. So we didn't want to just be out there serving summonses to bring in data that we wouldn't look at. It had to be managed in a way that we physically could go through the data and develop it and make headway. But again, very successful projects, very successful John Does. Through all of this, we identified a number of common offshore tax schemes that were used time and time again by people to move money. And we get back to those 4 questions again about getting the money offshore and controlling it and such. Some of the more common ones, first of all, obviously the use of sham entities. For us, a sham entity is any foreign entity that has no business purpose other than to disguise the ownership of the account. That's it in a nutshell. You set up an IBC, and that IBC doesn't do anything. All it does is show up as the nominee owner of the accounts that you not only beneficially own, but you control and have unrestricted access to. For us, that's a sham entity, and that's evidence of fraud, quite frankly, from our standpoint. Second is the diversion of income, where businesses take income and they divert it to offshore accounts. One common approach was what we refer to as mirror corporations. That would be where someone had a corporation here in the United States, or a business here in the United States, let's say, and let's say the business was XYZ Incorporated. They would form an IBC in a foreign jurisdiction, and they would name the IBC XYZ Limited. So you had XYZ Inc. and XYZ Limited. People would come in and buy your product or services, and they would write you checks. They would make it out to XYZ, and you would deposit some of them into your bank accounts here in the United States, and you would bundle the rest and ship them off via FedEx to your account in wherever. If you ever got audited or investigated by the IRS, you would produce all of your U.S.-based bank records, and guess what? They would reconcile perfectly to your tax returns, and more than likely you would walk away scot-free unless you tripped up somehow and made a mistake. So that was the use of mirror corporations to move money offshore. Another common thing was the use of offshore merchant accounts. Offshore merchant accounts are where a business especially e-commerce businesses, online businesses do this quite often. You have no fixed place of abode, and so what you do is you set up your bank account to be located in a secrecy jurisdiction. Then you hire a card processor who processes all of your credit card sales. Remember, you're not the purchaser now, you're the seller. And all of these credit card sales are being the proceeds are being handled by the processor, those very processors I named a few minutes ago. Except instead of depositing them into a bank account here in the United States, they deposit them into a bank account in a secrecy jurisdiction. Then if you don't file tax returns, who's to know? Now, that was another, we'll talk more about that in a little bit, but that was another common technique that was used by people to avoid taxation. Then there were false deduction schemes. A common one was false invoicing, where people would set up sham entities offshore, particularly in the consulting business, marketing business, certain types of industries that don't involve a lot of paperwork or product. And then they would sign contracts to hire those companies to do work for their U.S.-based business. So if I owned a business here in Miami, I might contract with a company located in a secrecy jurisdiction to pay them, let's say, $1,000 a month for consulting fees. Once a month, I would write them a check, and then when I file my tax return at the end of the year, I would write off $12,000 of consulting fees. All I've really done is move $12,000 of my own money into a bank account in a secrecy jurisdiction that I own and control and have unrestricted access to. And if I want, I could set up 3 or 4 of them. And now I could be moving $5,000, $6,000 a month offshore. Reinvoicing schemes. Very common practice we saw where people would set up an offshore corporation, and that corporation would purchase products needed for the conduct of business. An optometrist, for example, might buy their their frames for their glasses that they sell to customers, and they would use a foreign-based company that they control to purchase all of these goods, pay, let's say, $5 for the frames, and then the offshore business would sell it to the onshore business, the related business, for $10. Sort of like a mini transfer pricing scheme going on. But basically what you're doing, again, is you're sending $5 per frame offshore, and you're deducting it as cost of goods sold on your tax return. All you're doing is moving money around and not paying tax on it. And then there were false loan schemes. Once you had the money offshore, if you needed the money, you'd lend it to yourself. Make sure you have plenty of documents to support that this is a arm's length transaction, which of course it is not, but of course all the documents will show it as one. And then when you pay yourself back, you pay interest and you move more money offshore. Except now you're deducting interest on your tax returns for the payment of the fees, or payment of the loan. One of my favorites, I always talk about this, one of the best ones I ever saw was a couple that set up a college fund offshore. It was a scholarship program that anyone could apply to, and basically what you had to do was the candidate had to write an essay, had to submit all kinds of documents, just like you would do for any college scholarship or college grant. And at the end of it, they would select an individual to award a full scholarship, a full college scholarship to. The only two people who ever won the scholarship were the two daughters of the people that set up the scholarship. So basically what they did is they moved their money offshore. They didn't pay tax on it when they moved it, and then when they wanted to repatriate it, they paid for their children's college education using the fund by setting it up as a phony scholarship. And that's just the tip of the iceberg. I mean, I have seen some things that you couldn't, you know, I mean, some of you in the room maybe know about, but I'm going to tell you that I've seen some things that just shock me, the brazenness of what some people do. Anyway, those are some common ways that the money got moved. I have to tell you that I don't see a clock anywhere here, and I need to have some kind of guidance in terms of... Okay. Because I want... Okay. So anyway, now let's get to the Offshore Compliance Initiative. You know, after we got through the credit card project, IRS, I think, wisely decided, you know, there must be other ways that we can do this. Let's start taking a look at some other ways to identify people besides the credit cards. So we started coming up with some other initiatives. We came up with one called the Broker Initiative, which basically involved you know, in the United States, people from foreign countries who invest in the United States, in U.S. securities, don't have to pay tax on the profits from the sale of securities. They're exempt from that. So there's a real simple thing you can do as a U.S. citizen, which is to, again, form a foreign IBC and then do all of your stock trades through the IBC. Now you can say you're a foreign person conducting and you don't have to pay tax on any of the gains, and the gains are all paid into an offshore bank account. So we started looking at that, and again, very successfully. We started looking at electronic payment systems, the PayPal type of situation, and we found that PayPal was being used, and others similar types of businesses were being used to move money to and into and out of foreign bank accounts. So we actually served a John Doe Summons on PayPal in connection with that and identified a number of people who were doing that kind of activity. The offshore merchant accounts I told you about, where people set up IBCs in foreign jurisdictions and then had all of their credit card sales transferred to the offshore jurisdictions. We identified many, many cases from John Doe Summons that we served on the First Data Corporation for records of any merchant accounts located in certain secrecy jurisdictions where the registered owner of the account was a U.S. person, and then we looked to see whether or not they filed tax returns and paid tax on the monies that they were moving offshore. And that was another very successful one. And then the one that everyone has heard of, and that was the Offshore Private Banking Initiative. And that was really when everything changed. That's when we left the Offshore Compliance Initiative days and entered the UBS days. So let me tell you about that. It really all began when I met and interviewed a gentleman by the name of Bradley Birkenfeld in October of 2007. Mr. Birkenfeld, I met with him and interviewed him in connection with his status as a private banker at UBS in Switzerland. Based on the information that he gave me and also information I developed from other sources about UBS's cross-border banking practices, I determined that there was sufficient evidence that showed that U.S. clients were actively involved in accounts at UBS, and more importantly, that UBS was actively involved in soliciting U.S. clients while standing upon the sovereign soil of the United States. This was not about Swiss bankers doing what they do legally in Switzerland. It was about Swiss bankers doing it illegally while standing upon this country's sovereign soil. The investigation showed that bankers were specifically trained in how to avoid detection. They were required to use encrypted laptops whenever they traveled. They prepared false U.S. entry forms. Those of you who are attending this conference from a foreign country, you had to fill out these forms when you entered the country. They would fill them out falsely and say they were here for vacation when in fact they were here to visit their clients. They used secret codes in communication, codes that were used to represent monetary issues. And in one case, they even smuggled diamonds into the United States in a toothpaste tube on behalf of a client. Now, while IRS was conducting its John Doe Summons investigation, which is a civil investigation, the Department of Justice was at the same time conducting a criminal investigation of UBS's cross-border banking practices. And in February of 2009, UBS was entered into a deferred prosecution agreement with the Department of Justice, in which it acknowledged to participating in a conspiracy to defraud the United States and the IRS of lawful tax revenues. As part of the settlement, they paid $780 million fine. They agreed to exit the U.S. cross-border banking business. And they agreed to turn over to the IRS, or to the Department of Justice, rather, a certain number of client account records. The very next day, IRS, we went to federal court here in Miami, and we filed a petition for enforcement of our John Doe Summons. You have to remember, these were disconnected investigations. These were not, they often get reported in the media as a single investigation, but they were actually distinct investigations, the criminal investigation being conducted by the Department of Justice and the civil investigation being conducted by the IRS. The purpose of the criminal investigation being to look at UBS, the purpose of the John Doe Summons investigation being to identify the U.S. clients of UBS. 6 months later, in August of 2009, UBS, the government of Switzerland, the IRS, and the Department of Justice entered into a separate agreement that resolved all of the issues surrounding the John Doe Summons enforcement action, and they agreed to turn over to the IRS the names and account numbers of approximately 4,450 U.S. clients. And that was a watershed moment in offshore tax law enforcement, because for the first time, a foreign bank was turning over the records of thousands of U.S. clients to the U.S. government, records that previously had been protected by absolute financial secrecy. Those accounts held, according to the bank, more than $18 billion of assets. And the criteria for turning over the records was that any account they turned over had to have more than 1 million Swiss francs in it, or it had to have more than 250,000 Swiss francs and be owned by some form of nominee offshore entity. Either of those conditions, in general, I mean, there were nuances, but those were generally the rule. What the IRS did then was to say, well, you know, we're going to get 5,000 or so accounts to look at, and again, resources are limited. Let's announce an offshore voluntary disclosure program. Let's give a one-time, temporary opportunity to U.S. people to come forward and disclose their assets, and in exchange for paying the tax, the interest, and a significant financial penalty, we will waive any potential for criminal prosecution. It has been an enormously successful program. To date, it was first announced as a single event for a limited duration time, and then in response to all of the people that started coming in, not just from UBS, but from every continent in the world other than Antarctica, from, I forget how many banks, but it was like 600 different banks that were being identified. They decided to announce it a second time and then even a third time. And that third opportunity is still open, although I have read recently that in his departing statement from the IRS, Commissioner Schulman, who left in November, I understand that in his departure statement he announced that the time is running out for that and it will be closing soon, although there's been no announcement made that I'm aware of. It has been enormously successful. To date, 39,000 U.S. taxpayers have come forward. The IRS has collected $5.5 billion. That's billion with a B. According to a recent GAO report that was issued just last month, or a few weeks ago rather, only about 10,500 of the 39,000 cases have actually been processed and closed. So you can do the math in terms of, that's like 1/3 of the cases that have come in have been processed, and $5.5 billion has been brought in. So what's going to happen when they're all processed? The disclosures have also been a huge source of information, because one of the conditions of coming in was that you had to be willing to talk about who put you offshore and who managed your accounts, what banks were involved, what kind of practices, did they visit you in the United States, did they, what kinds of things were going on. And through that, by doing a series of data mining applications, a lot of information, a lot more information has been learned about offshore tax evasion and those who promote it, facilitate it, and enable it. In the meantime, IRS and the Department of Justice have continued with their efforts. In February of 2012, the U.S. announced a criminal indictment against Wegland Private Bank, the oldest private bank in Switzerland, founded in 1741, on charges that it helped wealthy Americans hide at least $1.2 billion in secret bank accounts. Wegland Bank has pled guilty to the charges. They've paid significant fines and penalties, and they have now closed down and shut their doors. They are no longer in operation. What Wegland had done was they attempted to take over UBS's departing tax evasion client portfolio and convert them into Wegland accounts. And they thought that they could do this and be exempt from prosecution in the United States because they had no physical presence here in the United States. Unlike UBS, which had a large physical presence, Wegland had none. But the problem was that Wegland failed to recognize all of the issues, the reputational risks associated with doing something like this. And not just the reputational risks for the bank, but for Switzerland. Because Switzerland, according to every media report I have read, is in the process of trying to resolve these issues. And this was an incident that showed that even after UBS, there were still Swiss banks doing this. And worse yet, when Wegland pled guilty to those criminal charges, they acknowledged at sentencing that this was a common practice in the Swiss banking industry. This was something that everybody does. Later, IRS issued a John Doe summons for the correspondent bank records of Wegland, which were maintained at coincidentally UBS in Stamford, Connecticut. And those account records will identify U.S. clients who moved money back and forth to Wegland through that account. And then just last week, IRS issued a John Doe summons to Wells Fargo Bank in San Francisco for the correspondent bank records of First Caribbean International Bank, which has offices located in 18 Caribbean nations. And those records will also identify U.S. clients who have been moving money to or receiving money from First Caribbean International through the use of its correspondent bank. Correspondent bank accounts are really the Achilles heel of the offshore industry because even if you don't have a physical presence in the United States, if you want to have United States clients and you want to enable them to send you money and receive money, which of course is the name of the game, you have to have some way to do it, and the way that it's done is through correspondent bank records. So I think I see this as a major development going forward, quite frankly. As far as criminal cases, as I said, the Justice Department has maintained a steady inventory or whatever you want to call it of criminal cases going forward. So far, UBS AG has agreed to a deferred prosecution agreement. Wegland Bank has pled guilty to criminal charges. There have been 19 employees and former employees of offshore banks that have been indicted, some of whom have been arrested. Others are still living in Switzerland or wherever they reside. But what this did is it showed that just because you're not living in the United States does not mean that you're beyond the reach of the United States. The United States cannot go in and remove these people and bring them to the United States, but certainly they can charge them. That charge goes on the record, and if these individuals ever do enter the United States, they will be arrested at the border. If they ever enter a country that has an extradition treaty with the United States, they could also possibly be detained. So it's not an easy thing. It's not something like, well, I'm outside the scope of your authority and you have no power over me. If you aid and abet in the commission of a crime in the United States, you don't have to be in the United States to be held responsible for that. And it's not just tax. That applies to any criminal statute. But 19 employees and former employees of offshore banks have been indicted. 7 independent financial advisors have been indicted. And 41 U.S. taxpayers who have used offshore accounts for tax evasion have been indicted. And many of those, when I say indicted, many of those have pled guilty. Many of those have been found guilty at trial. I'm not aware of a single case where anyone has been acquitted by jury trial. Not a single one. So, where do we go from here? Well, I think you're going to see more of the same. I really do. Particularly in the area of the correspondent bank accounts. I think that you're going to see more John Doe Summons coming related to correspondent bank accounts because it is the Achilles heel. It is the way of identifying the clients. And once you've identified the clients, it becomes just simple detective work. Quite frankly, if you know who the client is and you know the bank account number, most secrecy jurisdictions, certainly those in the Caribbean, have tax information exchange agreements with the IRS. So once we've identified that so-and-so has an account at, First Caribbean International Bank in Bahamas or whatever, we can go through the Bahamian TIA and request all of the account information related to that client. So the world has really changed. As I said in the beginning, offshore is not what it once was. I think that we're going to start seeing a reduction in the absolute nature of secrecy. I think that the time is coming when people are going to say that this concept of absolute, total, unequivocal financial secrecy protects no one except those who need it. We have financial privacy laws which are more than adequate for protecting the identities and financial affairs of law-abiding people. It's really only the crooks, the criminals who need the absolute secrecy. There's a saying, power corrupts and absolute power corrupts absolutely. In many ways, you could say the same about secrecy. I think the global nature of today's economy and today's the ease of use of internet, which make it possible to transfer money across borders with the click of a mouse, have made it to a simple thing for bankers to take advantage of. HSBC, what's their motto? The world's local bank. You can go anywhere and move money across borders by just the click of a mouse. Bankers no longer look at national borders as being a barrier to financial transactions. And I think that since 2000, since the Offshore Credit Card Project, since the Offshore Compliance Initiative, since UBS, I don't think the U.S. government looks at it that way anymore either. So I think that national borders need to be respected, sovereign laws need to be respected, but sovereign laws do not create a license to build a business model which has at its core the concept of helping citizens of other nations, particularly friendly nations, neighboring nations, violate the criminal laws of their home country. So with that, I don't know if I have time for some questions. If I do, I'll be glad to take a few.
Yeah. One question while she's taking the microphone over. What were the specific circumstances involving Bradley Birkenfeld? Did he come to you or did you go to him initially, if you're able to comment on that?
I became aware of Bradley Birkenfeld. Bradley Birkenfeld was not just talking to me. And so what I can tell you is that I requested an interview with him. Beyond that, I can't say anything.
He put himself out there, is that, if you're able to?
I can't say he put himself out there. I mean, I don't know what he did in the public.
You didn't find him on Craigslist or anything?
No, I didn't find him on Craigslist. I don't go to Craigslist. Who's Craig, by the way? Bradley Birkenfeld, it's a difficult thing to talk about because the only thing I can really talk about are the things that were in the declarations that I filed with regard to him. It's for Mr. Birkenfeld. He and his attorneys have released a lot of information. But I think it's his story to tell. It's not my story to tell.
And is the story with him that, because he claims he's been hard done by, notwithstanding the fact that, he's received in excess of $100 million, because he had to serve some nominal jail time. Did he withhold information? Is that, he feels hard done by. So is this a case of, he wasn't deemed to be totally honest and therefore suffered the consequence of that?
I think, well, first of all, you're talking about the criminal matters involving Mr. Birkenfeld, in which I did not have any role. His particular case was handled by the Department of Justice, and based on my understandings from the public documents that I've read, the lead prosecutor in that case has acknowledged that without Mr. Birkenfeld's contribution, there likely would never have been an investigation of UBS, a criminal prosecution of UBS. But at the same time, Mr. Birkenfeld, according to all the evidence, was directly involved in some of the activities. And so I don't think that he was exempt from criminal prosecution. When he went to the court to be sentenced, I know that the Department of Justice requested a certain period of time for his incarceration, and the judge ended up giving him quite a bit more. Why, I don't know. I mean, we can all speculate. Mr. Birkenfeld had gone on 60 Minutes the week before he was due to be sentenced and made some statements that may have hurt him. I don't know. But again, that's just my own personal opinion.
Including that he'd brought in the diamonds in the toothpaste tube that you'd mentioned earlier.
Yeah. In my dealings with Mr. Birkenfeld, all I can say is that the information that he gave me was all, not all of it, but I mean, the information he gave me was included in the declarations, and it was far and away sufficient for us to get a John Doe summons issued. And not just a John Doe summons. You have to understand that summons, I didn't say this before, but all of the other summons we're talking about are summonses issued on U.S. banks for records of offshore transactions. This was a summons actually issued on a foreign bank, ergo a Swiss bank. And it was because of a provision in international law known as a comity clause, not comedy like a Comedy Act. It's C-O-M-I-T-Y, I believe is the way it's spelled. And basically it's where a judge balances the interests of various jurisdictional laws to decide which ones are more important to enforce in a given situation. And we were able to, we meaning our attorneys, were able to convince the judge in this case that we had met the requirement to show that we should be able to serve this and enforce it in Switzerland. And I think that was a huge, huge turning point for us. But Mr. Birkenfeld's contribution was to the extent of the information that's in there. Everything else about him that's been said or released in the public eye, those are things you'd have to talk to him about or to the others that were involved. Certainly the criminal matters was outside of my scope. Anybody else?
Hi. You mentioned that a John Doe summons can be issued for just a single person. In what circumstances would you need to do that if you actually know the name of the person?
Well, I'll give you a classic example of one that actually occurred. Well, actually didn't occur, but we thought about doing it. But and this is an absolute true story. I was flying home on a plane from the OffshoreAlert conference about 5 years ago. And I was sitting in the plane, and in the seat behind me was two gentlemen talking about their offshore bank accounts. And this is absolutely true, I was sitting in my seat listening to them talk about the money and where it was and how the only thing I didn't know was who they were. So what I did is when I got back, sort of just like as a funny story, I told my attorney at Department of Justice about it, and he said, well, let's go issue a John Doe summons to U.S. Airways, find out who was sitting in those seats. And we made a policy call not to do it because we didn't want to create the appearance that IRS was eavesdropping on other people's private conversations. That's really the only reason we didn't do it. But there's a situation where we could easily have issued one and said who was sitting in seat 14C. You'll notice I wasn't in first class. 14C on this flight number. And we would have identified the individual and probably could have made a case easily. Anyone else?
Yeah.
Yes.
Yeah, I have a question. Bradley Birkenfeld said that Canadians had $5 billion on their assets at UBS, and mostly from hidden sources, and it was not disclosed at Canada. I've talked recently to Revenue Canada, and they said that only a very small portion of this amount of money has been founded. Are you surprised that other jurisdictions, for example Canada, are not following your lead in having these assets disclosed and to recoup the money?
I'll answer it two ways. First of all, I was part of a group to which Canada was a member that was looking at offshore tax evasion when I was with the IRS. And the people that I dealt with at Canada Revenue were very in tune to offshore tax evasion, and they were, they were very astute. They understood it. They were working on it. Again, Canada has different laws, so I don't know how those laws come into play. In our case, had it not been for the John Doe summons, I wouldn't be standing here today talking to you in all likelihood. And Wedlin might well still be in business, and UBS might still have their $780 million sitting in their bank accounts. The John Doe summons was part of what made it all possible. It may be, I know that not everyone has that authority. Sometimes the John Doe summons is referred to disparagingly as a fishing expedition by some. Usually people who don't want to be caught on the hook that is being thrown out. But I can tell you that, the John Doe Summons, if you want to make it any kind of an analogy to fishing, what the John Doe Summons represents is a license to go fishing. And it represents a license to go fishing because we have identified a particular pool of water that have lots of big fish in it. And we are doing it legally, in accordance with the law, fishing where there are fish. And I think the reason people refer to it so disparagingly is because we've caught many, many big fish along the way.
So this kind of mean is specific to the U.S., it's not...
But I didn't mean to digress from your question, but the main thing is that other jurisdictions do not have that authority. When I've traveled, I believe that Great Britain has something that allows them to do something similar. But all the rules are different. So with respect to Canada, I don't know. I don't know what might prevent them from finding this information out. But certainly I've not spoken to them about the issue.
Hey, Dan. You mentioned earlier a figure for the number of people who have taken part in the voluntary program with the IRS is about 40,000. It's a pretty big number, and it suggests that tax evasion is actually pretty common among people of certain means. Is there any context you can give us for that figure, or indeed from your own investigations, as to how frequent tax avoidance or evasion with offshore vehicles is among U.S. taxpayers?
Did you say context or contact?
How common is it? Is there any context you can give us?
Well, my belief, and again, I speak for myself only here, but my belief is that we have still only touched the tip of the iceberg. I think that there are the people who are coming in now, if you've read the GAO report, many of those are people who inherited funds, and they were people who didn't quite know how to bring the money back legally. That suggests that the people who set these schemes in motion, maybe they haven't come forward. You have to remember that at UBS, one of the pieces of evidence that was included in my declaration was a PowerPoint prepared by UBS, which showed that they had 52,000 U.S. clients, undisclosed, undeclared U.S. clients. They had a separate arm called, I believe it was Swiss Financial Advisors, that was the declared people. These were undeclared people. And 52,000, and that was just at UBS in Switzerland. And if you start thinking to yourself, well, if there's 52,000 at UBS, and if we throw in Credit Suisse, and if we throw in Julius Baer, and we throw in Wegland, and we throw in all of the other banks in Switzerland, and then if we include those in Panama, and those in the Caymans, and those in the Bahamas, and those in the Isle of Man, and those in Jersey, and those in Singapore, and those in Hong Kong, and those that used to be in Cyprus, and all of the others. If you start, you're talking about some serious numbers here. You're talking about some serious numbers here. What is that number? It's unknowable because, the problem with offshore is there is no definitive source of information you can go to. There are no financial reports being filed with the SEC or anything disclosing any of this. So it really becomes an art form to try and figure it out. I know that various estimates, which some may agree or disagree with, have placed the amount of wealth offshore as being in excess of $32 trillion. And various U.S. Senate committees, not just Senator Levin's committee, but others, have said that the loss to the U.S. Treasury is approximately $100 billion a year. That's serious money. The offshore leaks, I know we're going to hear about that tomorrow, but what has come to be known as the Offshore Leaks Project by the International Consortium of Investigative Journalists is just a small subset. And when you look at some of the names and the amounts of money involved there, it's extraordinary.
Hi, Dan. Thank you for this presentation. I'm wondering about the international cooperation dimension of of your work. Actually, this is quite impressive what you have done, as I understand. Not only for the legislation in U.S., but your way of work actually is quite impressive. I'm wondering if other governments are asking help from you for this kind of expertise. For example, we did a couple of weeks ago the ICIJ. We saw an ICIJ story about the BVI offshore accounts, but we didn't witness anything in terms of the U.S. taxpayers. So can we assume that it happened because of your work since 1990? Why we didn't see any U.S. taxpayers in this kind of stories? Because it's this kind of expertise, I think. And
First, I want to say up front that, I get a lot of the attention because my name was on all of the written materials. I often describe myself as the name on the marquee, but there were a lot of other people who were involved in this effort, and not just at IRS, but at the Department of Justice and others. So this was a whole team of people, many people who made this successful for the government. It wasn't just me. Having said that, I'm the only one that's retired so far. The rest are still out there, although some are getting very close. I will tell you that, I've had some people express interest in learning what we did and seeing whether or not it could be transitioned into their jurisdiction. Other foreign countries who are facing similar problems. None have directly approached me and said they would like to talk to me directly. I'd be certainly willing to talk to anyone about those kinds of things. But that's, right now, my efforts were directed at U.S. taxpayers who were evading tax. Obviously, any nation that relies on taxation is facing similar problems. I have done some work with some NGOs that are looking into this since I retired, but I'll let them disclose that. I hope I answered your question. The BVI, have I been approached by the BVI? Is that what you... Well, there are many U.S. taxpayers who use BVI corporations. I mean, BVI is one of the biggest sources for international business companies in the world. They're a small country. I'm sure there's a few of you here, but they're a small country that has a small population. I think it's about 22,000 people live on the island, most of whom are involved in the tourism business. And yet, according to their own reports that they publish once a year, there are over 600,000 active corporations registered in the BVI. So it's a very big source of the problem, quite frankly, but it's also a big moneymaker for the island. So, that's the dichotomy we find ourselves faced with. As I said, I think that the solution really is that for financial centers, for offshore financial centers going forward to continue or to prosper, they're going to have to start looking at revenue sources other than tax evasion money. I often, when I attend these conferences and with some of the people in the room here, I've had discussion about, all of the good things that offshore financial centers do for the world, according to the individual speaking. But when you get right down to it, tax evasion is where most of the money comes from. And that's because it's easy, it's simple, you don't have to go hunting for it, you don't have to work hard, it just shows up on your doorstep. And the source of the problem is right here in the United States. It is the American citizens who want to evade tax, and also there are U.S.-based lawyers. One of the big problems I've talked about is the blurring of the distinction between what used to be obviously obviously tax evasion and obviously tax avoidance. They're two separate concepts, and yet we have somehow blended the two over the last 20 years or such, to where reputable U.S. law firms look at structures set up by promoters and say, yes, this is perfectly legitimate, perfectly legal, and then we go in and look at it and investigate it, and it turns out to be massive tax evasion. There was a huge one that was exposed by Senator Levin's committee called the Point Strategy that involved billions of dollars of phony losses being generated that never took place, all through the use of international business companies and foreign trusts. And that's because the law firms never looked at anything but the structures involved. They never looked at what was behind the structure to see if there were actually any sales taking place. So it is a huge problem. And I think that the solution is to start looking for ways to generate money other than the easy money that comes from helping people commit tax evasion in their home countries.
Are you concerned about traveling to certain countries, and have you or other IRS agents been advised not to travel to certain countries?
During the heyday of UBS, when it was really going on, I won't say who suggested it, but it was suggested I should not go to Switzerland on a vacation. Now, I should tell you that I love Switzerland. What many of you don't know is that I was born in Europe. I never saw the United States till I was 18 years old, and I came here to go to college. My mother is French. My father was part of the World War II effort. So I grew up I was actually born in Germany, grew up in London, spent much of my time in France and Switzerland and Austria, and have a great fondness for all things European. I think Switzerland's a great nation. I think it's a great people. I would love to go back just to visit because it's a beautiful country. I hope that enough time has passed that wouldn't be the case, but I must confess that I was a little startled about a year or two ago when the Swiss they issued arrest warrants for 2 German tax officials who had never set foot in Switzerland. They were in Germany, and someone had turned over to them a stolen CD of information on Swiss banks, and the Swiss government actually indicted and attempted to arrest these German tax officials for doing their job in Germany. Talk about extending your sovereign laws outside the borders. So I'm not sure I'm ready to go back to Switzerland yet. I have to tell you, my son was married last year in Greece, on one of the Greek islands, and I had a choice of connecting through Zurich or connecting through Rome. I went through Rome. Anything else? I hope I'm not keeping you for lunch. I was once told never keep them for lunch.
I appreciate what you said earlier. You weren't involved in the Department of Justice investigation, but can you tell...
I'm sorry, I wasn't involved in what?
In the Department of Justice investigations into UBS. But do you know on what basis Wegland Bank were prosecuted?
Wegland Bank, and again, you have to... I'm going to give you my spin on it, but that's not the official. But Wegland Bank was soliciting the departing clients of UBS, they hired a former UBS private banker, and what they were trying to do was get all of the clients of UBS the U.S. clients to transfer their funds to Wegland, and telling them that they would remain secret, they would remain tax-free, basically saying we will do everything for you that UBS used to do for you before it got indicted. So, as I said earlier, that constitutes aiding and abetting in the commission of a crime. You don't have to be standing upon U.S. soil to violate the laws of the United States, and we've seen that through all kinds of things, drug trafficking and all kinds of other things. Now, the specific charges, I would have to say, read the indictment or contact the U.S. Attorney's Office in New York. I don't want to speak for them, and I certainly don't want to misspeak for them. But that is my understanding of it.
So is it the case then that any business around the world which is doing business with American citizens have to be conscious or aware of the fact that
I think they do.
they're not committing an offense under U.S. law?
Yeah, I think what they do. I think that what I said earlier about it, there was a time, remember I started this off by saying offshore is not what it once was. There was a time when if someone came to a particular financial center and wanted to open up offshore bank accounts, the banker could openly discuss tax evasion as one of the best reasons for doing it, telling them how to set up a nominee corporation, how to move the money, set up a false invoicing scheme. You can do this. And I've seen many of this advertised brazenly on the internet by financial service providers. I don't think you can do that anymore. I think that when you do that, you have to understand you're aiding and abetting in the commission of a crime in the United States when you do that for a U.S. taxpayer. And you can be charged.
So the solution then is not to deal with American citizens?
Well, if your purpose is to help them evade tax, I'd say yeah. If your purpose is to help them do something else with their money, then I would say feel free. But if your business model is based on helping people commit crimes, whether it be tax evasion, which is seen as a soft crime in some places, even a hobby, or whether it be on selling of narcotics, or whether it be on selling of phony schemes. Whatever it is, if that's the business model you're based on, then, you know, your days are numbered. You know, there's a great, I was a big fan of Bob Dylan growing up. And Bob Dylan has a great line in a song called "The Times They Are A-Changin'." He said, it's time to get out on a new road if you can't lend a hand. And I think that for those of you who are involved in the business of offshore tax evasion, not offshore financial centers, I'm not going to get into all of the other things that financial centers do, but in terms of tax evasion, helping people commit crimes in their home jurisdiction, it's time to get out on a new one if you can't lend a hand. Because believe it or not, the times they are a-changin'. Anyway, thank you. I hope you enjoyed it. Good luck. Enjoy